Uh, May please, your lordship.
Yes.
My lord, in connection with item 4,
Hmm.
my lord, I beg to mention, my lord, this particular item. My learned senior friend, my lord, for item 4 is present.
Lord, I am also a respondent. He is also a respondent. He is for the government. So
Yes.
he has also filed a appeal against the same judgment. So he prays that both the case may come together.
My lord, in fact,
Appeal is numbered.
no, yes, my lord, filing number is there. My lord, I will correct it. What I'm saying, my lord, it may be listed on Thursday along with item 4. My learned friend has agreed to that proposition, my lord. 4 may also come on Thursday. That is 5th, my lord, along with my matter.
Is it filed within time?
Yes, my lord. It's within time, my lord. It's within limitation, but it is not listed.
Oh.
My lord, I am told there is some defect. I'll correct the defect, my lord, and let it come on 5th, my lord. My learned friend, senior friend, has, my lord, agreed to that
It is the
proposition.
same judgment.
Same
I was
judgment.
the respondent in the petition.
Yes.
He is also.
So if it comes together, then it will be convenient for all the parties, man.
Okay, Mr.
My lord, my lord, item 4, my lord, it's Mr. P.K. Roy Chaudhary.
No.
My lord, this is a mention memo. I'll place there, my lord.
Okay. Okay. Then on your request, I'll list it.
Not my request, man. The request of he is the respondent here in the writ appeal, man.
Oh,
On consent of both the parties, my lord.
you're the cooperative society?
Yes, my lord.
Okay, on request made by Mr.
S.K. Talukdar.
S. Oh, so you're the standing council cooperative department.
And the caveat is also there, man.
I'm caveated there, item number 4, man.
Okay, list on.
5th, my lord. Past tarik, no? Brihaspatibar.
You want it on a Thursday?
Thursday, my lord.
Okay, very
5th
good.
one.
Obliged.
Obliged.
What should I beg to mention item number 2, sir? Just for Passover for the day, madam. My senior's name is not reflected.
You are for the appellant
Appellant, madam.
on request made by M. Sharma. Your name is not here.
My name is not here, my lord. In fact, I am making this mention on behalf of Mr. N. Sharma. He's on legs in a separate court conducting a matter, madam.
On request made on behalf of Mr. N. Sharma, then counsel for the appellant. When do you want?
I'll leave it to your lordship's convenience. I'll leave it to
After a
you
week?
after a week or preferably next week as per your lordship's convenience.
After a week.
Grateful, madam.
May please, your lordships. My lord, I am praying for a listing of a motion matter. My lord, we have filed it last Tuesday. It pertains to rejection of the petitioner's candidature for grade 1 judicial service. And the advertisement has also been issued. So third party rights should be accrued. So I am praying the matter may be listed on Monday or Tuesday as far as lawsuits concerned.
Tuesday.
Tuesday. Deeply.
Item 1 for orders.
Lordship, here I have preferred an appeal against the
Delay.
delay is there, Lordship.
But Mr. N. Nobody. Learned. Standing council, irrigation
Lordship,
department
Lordship.
for the appellants. Issue notice. Appellants to take steps for service of notice on the respondents, 1 to 7.
1 to
No,
6, Lordship.
1 to
7, my friend is there.
By registered proceeding within 1 week. Who appears?
7, lordship.
Mr. P. Nayak, from the Standing Council Finance, appears on behalf of the list of the 4 votes.
Item
Let
3.
the appeal be numbered, Lordship.
How can I number your appeal
Lost.
before your condemnation is
Lordship.
condoned?
Item 3.
Majumdar, you are the
I'll be here for the department, my lord. For the education department.
item 3.
Oh, item 2 is written. I'm sorry, Mr. Item number 5.
On appears for the appellant. List. On second. I have it on my side. I think there's some urgency. Yeah.
Madam, I am 4. Madam, I am 4, madam. Item 4, madam.
Mention to it.
Only
Sorry. I have to accept this, madam.
Is here notice only has to go.
May I please, your lordships? My lord, this is a matter, my lord, wherein we have challenged a particular part of a rule, my lord. But my lord may be pleased to find the rule, which is at page 46, my lord, Annex 5.
Hmm.
If my lord may be pleased to take up substitution of the schedule 2, they have done, my lord. Criteria for selection of the graduate teacher, postgraduate teacher, including subject teacher in vocational subjects. So, my lord, my lord can skip the first few part A, B, 1 and 2, my lord. We are concerned with the 2. 3, my lord. Amendment of rule 3. In the principal rule in schedule 3, I am reading the last part of the last line of this page, my lord. In the principal rules in schedule 3 in clause 1 in 4th line, after the words as valid for the punctuation mark shall be substituted and thereafter the following words shall be inserted immediately. The candidate shall have to read the same subject as one of the subject in degree level. My lord, I have moved a petition, my lord, before my lordships, my lord, regarding that the Assamese, those candidates, my lord, who are intending to, my lord, present their application for the post of postgraduate teacher in Assamese, my lord. In the non-amended rule, my lord, there is a provision that those persons should have some specialization or the honors in the graduate degree. Now, my lord, by substituting that part, they have make a part that any of the subject, if a person is intending to, my lord, apply for the post of Assamese postgraduate teacher, if he has a pass course in the degree, my lord, then he can apply in pursuant to the amended provision of this rule. So, my lord, we are saying that as we are, my lord, having an Assamese as a honors in our graduate, my lord, so we should have get the preference in terms of the earlier rule. Now, my lord, in what the state government has done in respect of mathematics and other subjects, my lord, they have given the privilege by amending the rule that those persons who have the, my lord, honors in the graduate degree with particular subject, then they can only apply for that particular post. Now, here is a case wherein, my lord, they have completely taken a U-turn that it has been made a rampant, my lord, applications can be allowed if a person having SMS in their degree as a pass course or any other, my lord, from university, my lord, through the distance mode, it has been made an wholesale applicability of that provision, my lord. That's why, my lord, now what is happening, a large scale sum of the persons, my lord, who do not have the degree from the some authorized university also, we have the information that by taking recourse of this provision, my lord, they are applied. Now, my lord, it is a case wherein, my lord, the career of the students is also going to be compromised, my lord. Some persons do not have that expertise, my lord. As we are a graduate degree holder with honors as an Assamese, my lord, we have the expertise. So, in terms of the non-amended rule, we could have been given the preference, my lord. So, this is in violation of, my lord, constitution, my lord. Today, my lord, if my lord may be pleased to issue notice, my lord, some other similarly placed cases are also there, my lord, regarding mathematics and Hindi also, my lordship is examining, my lord.
Yeah, Majumdar. But yeah, we have learned counsel for the petition.
Subject
Issue notice. Mr. R. Majumdar, learned standing counsel, school education department or
Yes.
secretary?
Department of School Education.
Department of School Education. Appears on behalf of the respondents, on behalf of all respondents.
My lord, only my limited, I am not asking for any interim, only if my lordship may be pleased to observe that the post of Assamese, wherein, my lord, that shall be subject to outcome of the repetition, my lord.
This place, my lord, the rules came in 2023. The last date for application expired in 2024. Now seeing a competition, we are trying to have an advertisement being affected by challenging a rule now. This will not be allowed.
Respondents are allowed to file extra copies. Please, how much time you require?
Lordship would give me 4 weeks, my lord.
4 weeks.
4 weeks to 2 weeks.
My lord, in the meantime, result is going to be declared today, my lord.
Now why the subject to outcome? Why they had
Quite
to be?
late. We are.
My lord, no, my lord, what has happened, my lord, this rule, they have amended, it has not been notified in a proper manner. When I moved to, my lord, when we moved the petition challenging the advertisement, then only, my lord, that notification, this amended rule had been placed before my lordships also, my lord. So, my lord, just an observation, I am praying that subject to
No.
outcome, my lord.
After the selection
After
process,
so-
Pratas.
My lord.
Obliged.
My lord,
Oblige, my lord.
I'm extremely, my lord, my item is item number 3, my lord. I'm just late, my lord. Slightly, my lord. Item number 3, my lord.
You are appealing for?
My lord, for the appellant, my lord.
Okay.
My lord, in this matter, my lord, may I submit, my lord?
Yes.
My lord, in this matter, my lord, we are, my lord, challenging the judgment and order dated, my lord, by the learned single judge, my lord.
You are aggrieved by what?
My lord, thing is this, my lord, they have, my lord, misrepresented, my lord. What happened, my lord? They have
Fine.
shown some false credential, my lord.
Okay.
So, my lord, as per the contract clause,
So
my
that-
lord, tender clause, my lord, they will forfeit the earnest money security deposit, as well as they will be debarred from participating for a period of 5 years, my lord. So, my lord, lordship, my lord, forfeiture is, my lord, held to be, my lord, upheld, my lord, by the honorable court, my lord, by the single judge, my lord.
You want to be that company to be blacklisted?
My lord, that things, my lord, thing is this, my lord. What happened, my lord? Here, my lord, it said, my lord, it is, my lord, too harsh, my lord. But, my lord, there are various, my lord, cases, my lord.
Okay, we'll consider the
Yeah,
matter.
my lord, what happened, my lord, it will affect, my lord, in other cases, my lord. In all other cases, my lord, this order will affect. Only that the lordship may kindly say, there is an.
If you want, we can issue a notice and then we pay it under things. Yeah. Yeah. We'll issue a notice.
My lord.
Heard G goes on. No, standing council railway.
Yes, my lord. My lord.
Issue notice. Appellant to take steps for service of notice on the sole respondent,
Yes, sir. Yes, my lord.
sole respondent by registered post 80 within 1 week. List after 4 weeks.
Deeply applied.
Item 6,
What is this? Sorry.
Wait, please.
Oh,
Lordship, the petitioner has applied applied for DM permission for taking over physical possession of the secured assets of the respondent number 4, Lordship, under section 14 of SRPC. But even after expiry of 60 days, the order has not been passed, Lordship. DM Dibrugarh.
I think the direction from the Supreme Court, they have to approve it. Oh.
Lordship, Annexure 3, page 33.
Okay, we issue notice at this stage. Heard, Mr.
D. Go away.
No, council for taking. Petitioner. Issue notice. Which department is respondent number 1?
District Magistrate.
No, number 1.
Lordship.
Which department?
Lordship, Commissioner and Secretary, Government of Assam.
Oh.
Dispute.
How many commissioner and secretaries are there in Assam? You amend your respondent 1 list.
Petition, Lordship.
The address of the respondent number 1.
Lordship. I may be allowed to amend the sum, Lordship.
You'll have to file an IA format.
Lordship.
Mr.
D. Go away.
The counsel for the petitioner is permitted to file an IA for correction of the address of the respondent. List
Alright.
after 1 week.
Lordship. Obliged.
Procedural.
Yeah, Barbuya?
Yes, my lord, I beg to my lord withdraw this petition with liberty to file a fresh.
Mr. M. Barbuya then calls for petition, press for withdrawal of the suit. With liberty to file a fresh. Elementary? Mr. B. Kaushik, Leonard Standing Council, appears for the elementary. Department. And finance, anybody, Mr. A. Chalia, Leonard Standing Council, appears for the finance department. With petitions dismissed on withdraw with liberty expected. I also will have to go there.
Yes, sir.
In view of the order first to remain with I stands disposed.
Obliged.
Item 1, orders.
With the order and the review,
Your Lordship, the one dated 19/2/2018. Last portion, Your Lordship, at page 22.
yes,
Your Lordship, in that view of the matter, the court is of the considered opinion that the impugned letter dated 2/1/2017 is vitiated and the same is accordingly set aside and quashed. The respondents are directed to consider the case of the petitioner for dependent employment, compassionate appointment against the next immediate vacancy that arises in future. Your Lordship, you agree by this? Your Lordship, we are governed by the National Coal Wage Agreement.
okay,
And there is no provision there for appointment against any next future vacancy. These are one-time appointments against the death of a father or mother. That vacancy does not come automatically with time.
Hmm.
That is,
you were represented, isn't it? On the last, when the writ petition was disposed of,
yes, I was.
you were represented.
Yes, yes.
Why couldn't you bring this to the notice of this?
Your Lordship, this was. We had stated this, but Your Lordship had passed the order. We did not. The order was passed on 2018. And I mean, I look at it.
It was oral judgment. Yeah, present lordship.
Mhm.
Income complete set to us and certificate file solution. 19/2022. After an Excel 5 years, 9.3, 9.4.
We had energy provisions which we had relied on under the National Coal Wage Agreement, which is NHS 5 to our affidavit.
Page,
It at 9/10/2000.
The generation current line.
9/10/2022.
You had filed it on 9/10/23.
In your affidavit.
Yes.
Which affidavit?
On dated 9/10/2000.
Your Lordship,
Which affidavit?
this is
Dated
a
9/10/2020.
affidavit dated 9/10/23.
9/10/23. You filed an affidavit or what?
No, this was filed earlier with the writ petitions. The
No, no,
provision is
You've annexed that in the review petition.
review petition, we have not filed.
Then
Subsequently.
after filing the review petition, you filed an affidavit.
Yes,
That is dated.
9/10/23.
You have a copy, da?
Yes, Lordship.
9/10/2023. Okay, page 27.
Page 23.
No,
Yes, 29.
With NHD extract of the toll wage agreement.
Yes.
That is at page 29, and the relevant portion is at page 30. Direct amendment.
And then to be considered. 9.3 name.
Which para?
9.3.3.
9.3.
Huh? No, it's you kill my bit to you.
The dependent for this purpose.
The dependent for the purpose means the wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, brother, widowed daughter-in-law or son-in-law residing with the deceased and almost wholly dependent on the earnings of the deceased may be considered to be the dependent of the deceased. Nine point 3.4. The dependents to be considered for employment should be physically fit and suitable for employment and aged not more than 35 years, provided that the age limit in case of employment of female spouse will be 45 years as given in clause 9.5.0. Insofar as male spouse is concerned, there would be no age limit regarding provision of employment. Here, this is the case exclusive appointment against the death of the father or mother. So in this case, the Lordship had accepted that the time had passed. It was beyond a reasonable period. And the Supreme Court has time and again held that compassionate or dependent employment is only for emergent situations. Soon after the person dies, a son or daughter who is eligible can apply and be appointed within a reasonable time. Here, post my no, I don't know. Any post. Vacancy that create only. The post gets created only in the event of the death of the father or mother.
Financial condition or something.
It's not a normal vacancy in normal course. It is not that after the father dies, the son gets the appointment automatically. There's no vacancy created. There's no other person who is
You requested the mother
mother.
to file her application for completion of grounds. Read the judgment. This judgment is just reiterating the earlier judgment passed by this court.
Yes. The mother, she withdrew, she did not want the compensation. And subsequently, the son applied, much belatedly. And the son application was rejected on the ground of delay.
The financial condition that time too much send upon engages.
Before you come to this judgment, you'll have to come to the judgment passed in WBC 3091 of
I'll
2016.
come to that.
You'll have to cross that hurdle first. This court was reiterating what was what is stated in this
Earlier
judgment.
judgment, right. No, I'm not disputing all that regarding
If
the
you are not
judgment.
disputing, then what can we do?
No, but there is no question of in the earlier judgment also, there is no
Only that portion of the
question raised that there will be a vacancy.
only
There is no future vacancy.
only that portion of the investments.
We are concerned only the last line in your lordship's judgment. Your lordship directed that the petitioner be appointed against the next immediate vacancy that arises in future. That is something is not possible for us to do. There is no future vacancy concept.
See, your rejection of the petitioner on two grounds.
Yes,
Number one, he applied late.
late.
Number two, he was employed in Singapore.
Singapore,
For these are two grounds.
two grounds.
Late employment in the first fit petition, this court has made it very clear. Second employment of Singapore in this judgment under review. This court has come to the finding that when the petitioner made the application, he was not employed.
At that
At that point of time when the petitioner made the application.
But otherwise, he had a normal source of income. He had been working.
At the time of
He was working, but he was working up to 4/1/2011.
Yes. But your
When
lordship
the
is,
petitioner made the application, he made the application on 19/12/2011.
then what happened?
petitioner was working in the time of date.
The petitioner was initially working at the time of death of his father. He was in employment. And what does the Supreme Court say? Employment is only
94 4 SSC 138.
eligible CS
Do one thing. We'll take it up on Monday. You come prepared. Okay.
On Monday, can it be Wednesday?
Time is running short for this court.
We understand, but you won't be here.
I don't know. I don't.
There,
I'll be out of station.
paragraph 10 and 11, though. Paragraph 10 and 11 of the review petition there. Like,
Review petition, maybe.
at page 10, Lordship, of the review petition. Paragraph 10 and 11. The requirement to file the still review petition arose only when the contempt case number so and so was taken up for final hearing on 11/9/2023. When the interpretation of next vacancy arose and the concept of next vacancy in the method of compassionate dependent employment arose for consideration, the said contempt case is now fixed for hearing. That unless the clarification as sought for is given by this honorable court, the review petitioner will not be able to appoint the petitioner in any regular post against which vacancy may arise. More particularly, when the concept of next vacancy is not contemplated in the NCWA, based upon which the dependent or compassionate appointment can alone be granted.
We made it clear.
Guidance specifically that to appoint me.
No,
That
against,
that will-
against next vacancy. What does next vacancy? mean?
So that next vacancy, you don't want it. You want it. You then we are. You appoint him in the furthest post.
The present there is no post because he had missed the bus.
I'm sorry.
Lordship, I'll leave it to you, Lordship. Lordship may pass the judgment. I have no problem.
Lordship, we have also annexed in our reply that the appointments made on 9/5/2018 to several persons at page 38.
Those are against specific vacancies against persons who died.
That Lordship's order as judgment was passed.
There's no relationship with this.
Okay. We'll take over on Monday then.
Monday, Lordship, we won't be here. We're out of station.
Okay, but Mr. MZ Ahmad, then the council for question as well as RR. Then council for the respondents,
Respondent.
respondent of the week petition.
Respondent number 1.
List down. Fifth. What the
Fifth.
sixth?
Will,
Fourth.
as you mentioned.
Lordship will pass the judgment.
Pass the.
No, side है, side है.
Deciding.
May please, Lordship. The miscellaneous application for restoration of review petition, Lordship. The annexure 5, Lordship, in the miss case, page 37 is the order,
Annexure 5.
annexure 5,
Page.
page 37.
Thirty-seven.
37, Lordship.
47 is the cost title. Review petition 140.
No, Lordship, that is miscellaneous. Lordship may take up the miscellaneous application. That is for restoration.
Okay, this case. This case is for
The restoration of the review petition. That was dismissed for default, Lordship.
page 37.
Page 37, annexure 5, Lordship. Order dated 24/5/2023.
Oh. And what is the IA?
I for condonation of delay. in preferring the miss case. There is a delay of 256 days.
So IA has to be taken up first, not miss case.
Lordship has issued notice, they have entered appearance also.
That's why we'll have to consider the IA first.
Yes, sir.
Even only if it is condoned, then we can consider your restoration.
That's correct.
Anybody appearing in the IA?
And for respondent number 1.
Your respondent number?
1.
Okay. And 2? You are appearing?
Respondent number 2.
You are appearing?
Yes, Lordship. Lordship, on the last occasion, we have submitted a death certificate of respondent number 2. He had expired on 16/12/2024. So
16?
it was instructed. Yes, Your Lordship, 16/12/2024. Lordship, necessary steps were to be taken by the petitioner regarding this.
That is not recorded.
It is recorded, Lordship. The order has been passed in miss case, Lordship.
In the miss case.
Yes, Lord.
Which order?
Order dated 9/5/2025.
Have you taken steps?
Lordship.
Have you taken steps?
No, steps have been taken, Lordship.
Now, whether you'd like to continue against the respondent number 2 or whether the legal heirs of the respondent number 2 will have to be impleted.
Lordship will take steps by the still, Lordship.
Number 2 is dead.
Yes,
All right,
yes, Lordship.
in the IA.
Yes, Lordship.
Now, what do you plan to do? You want to continue with number 2 or you want to implement the legal heirs?
Legal heirs, Lord. Lord, legal heirs, Lordship.
In the IA, you put the IA first, after the heirs. Mr.
M.K. Bora.
Learned counsel for the applicant. Praise for,
Taking steps.
not steps. How much time you require for implement?
Well, 2 weeks, Lordship.
Praise for 2 weeks time to file an appropriate application for implement of the legal heirs of the respondent number.
2.
That is Mustafa of the respondent number. List after 2 weeks.
Apply. Item 3.
Wait, please, Your Lordship. Straight away, I will like to take your lordship to the order, my lord, against which contempt is being alleged. Lordship will find the order at page 31.
One minute.
Order starts from page 32. May I just read from third paragraph of page 32? Under what circumstances this order was passed, my lord, that's very important. Raising a similar grievance, the petitioner herein had approached this court by way of instituting a WBC number so and so. This court, by order dated 24/11/2022, had disposed the said writ petition by requiring the District Scrutiny Committee for Secondary Education to consider the case of the employees of the said school for such provincialization under the provisions of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. In pursuance of the said process, the case of the petitioner came to be placed before the district level scrutiny committee, and the recommendation of the district level scrutiny committee were forwarded to the inspector of school Kasar, to the director of secondary education by communication dated 20/05/2023. Today, so and so learning standing council secondary education department in terms of this court's earlier order has placed on record the instruction to that effect that the recommendation made by the District Scrutiny Committee in favor of the teachers of Rajpur High School has been received by the District Director, Secondary Education, Assam, and the matter is being processed and would be placed in the next meeting of the State Level Scrutiny Committee. In view of the said development, this repetition stands disposed, my lord, kindly mark this, directing the Director of Secondary Education, Assam, to expeditiously place the case of the petitioner in the next meeting of the State Level Scrutiny Committee, and thereafter, basing on such recommendations, necessary orders for provincialization of the service of the teachers of the school in question be issued at the earliest. The entire exercise for the purpose of taking the recommendation in favor of the petitioner made by the District Level Scrutiny Committee to its logical conclusion be initiated and completed within a period of 3 months from the date of receipt of a certified copy of this order. So, my lord, here, my lord, there is twofold direction. One is because as per section 13(7), the District Scrutiny Committee once forward the list of the verified teachers. 13(7) mandates the director to place it before the State Level Scrutiny Committee. Now, the second fold of is if the State Level Committee recommends further, then the director role will again come for issuance of provincialization order. Now, my lord, the pursuant to this direction, within 3 months, my lord, the director has placed before the district State Level Scrutiny Committee on 29/2/2024. And the minutes of the State Level Scrutiny Committee, my lord, will find at page 60.
60.
Page 60 of the affidavit.
Your affidavit.
Affidavit filed by the director with the sole respondent.
Yes, page.
Page 60. This is a meeting minutes of 29th of February 2024. Page 61, my lord, will find the serial number 6. The petitioner. The State Level Scrutiny Committee rejected the recommendation of the District Level Scrutiny Committee. So, my lord, thereafter, the director at page 63 has passed this order. May I read it? Whereas the Honorable High Court order dated 5/1/2024 passed in WPC number so-and-so filed by the so-and-so, wherein it is stated that the writ petitioner stands disposed of directing the Director of Secondary Education to expeditiously place the case of the petitioner in the next meeting of the State Level Scrutiny Committee, and thereafter, basing on such recommendation, necessary order for provincializing the service of the teacher in school be issued at the earliest. The matter of so-and-so was placed before the State Level Scrutiny Committee. Meeting was held on 29/2/2024 in the said SLC meeting. The committee, by its resolution number 2 under point number 6, did not recommend the name of the high school for provincialization due to the fact that, as per the report received from the Secretary Seba, only 22 students appear in the HSLC examination during the year 2015, whereas the minimum students required to appear is 25 as per section 3(5) Roman 5 of the 2017, as amended in 2018. The section 3 Roman 5 states venture education institution has a minimum total enrollment of 25 students in class 10. In view of the above facts, as per the resolution of the State Level Scrutiny Committee, the claim for provincialization cannot be considered, and thus the Honorable High Court passed in WPC number so-and-so is complied with. Now, if your Lordship kindly takes up the act also, my lord, because the direction was to the director to place it before the State Level Scrutiny Committee. So, therefore, my lord, in my respectful submission, on being placed within 3 months, my lord, that direction is complied. Now, my lord, kindly see page 122. The section 13 starts from page 120. The relevant would be section 13, subsection 7. The District Scrutiny Committee shall forward the verified list of eligible teacher based school wise in accordance with this act to the concerned director, who shall place the matter before the State Level Scrutiny Committee to be constituted under subsection 10. and after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institution and teachers eligible for getting their services provincialized. And therefore, my lord, this honorable court directed the director to place it before the state level scrutiny committee, because the director role is that much only. And once the state level committee, if would have recommended it, then the further role of director would have come for sending it to the government. Now, section 1312 also makes out a provision that when there is a difference between the recommendation of the district level and the state level scrutiny committee, it is the state level scrutiny committee whose recommendation will be final. So in my respectful submission, my lord, the direction has already been complied with. Now, if the petitioner is aggrieved by this order, it would be a new fresh cause of action for challenging.
May I submit, Your Lordship? Your Lordship, may I kindly see 10, the next page, 123. There shall be one state level scrutiny committee at the state level for verification of recommendation received from district scrutiny committee with the following members, namely director of the concerned Department of Education as chairman. So, Your Lordship.
And the other members also.
The other member also there.
It's a committee.
The resolution has been adopted by the state level scrutiny committee and chairman being the, and a director being the chairman. So it cannot be denied that director's role finished soon he placed the matter before the state level scrutiny committee. The Lordship may kindly see on last occasion they have submitted an order 19/5/2025. Maybe on record, Your Lordship. On last occasion they had submitted stating therein that they have complied. A page has been served on last occasion. Lordship, second para and third para, the matter of the Rajpur High School was placed before the state level scrutiny committee meeting, which was held on 29/2/2024. In the state level scrutiny committee, the committee by its resolution number 2 under point number 6 did not recommend the name of Rajpur High School for provincialization due to less number of students. That is 22 appeared in ACLC exam in the year 2015. That is correct. Whereas the minimum student enrollment required is 25 as per section 3(5) of the Assam Provincialization of Service of Reorganization of Teachers Act 2017 as amended in 2018. So the thing is that they have used the two terms, appeared and enrollment, by giving the same meaning.
That is the decision of the SLC,
Yes, it can't be the same meaning.
SLSC.
Yes, the enrollment defines, Your Lordship, the students whose names are registered in class 9 or in class 10 who shall attain HSLC in the next subsequent year.
See, are we supposed to go into this?
Yes, Your Lordship.
The direction was the
Yes.
director was directed to place it before SLC.
Yes, yes,
And on the decision taken by the SLC, director
Yes.
shall pass upgrade orders.
yes,
Correct.
yes,
Immediately director place it before SLC.
yes,
SLC considered the matter
yes,
and then came to the decision that you have an enrollment, you have a pass,
appeared is
students of 22, whereas as per the act, there should be 25 enrollments.
yes,
Correct.
yes, yes,
Thereafter, director passed the order saying that you cannot be, your school cannot be provincialized.
yes, yes,
Now, the first part of the judgment that was passed by this court
Court.
was place it before SLC on the basis of direction passed by the on the basis of the recommendation or any finding of the SLC, director shall pass orders.
yes,
Correct.
yes,
Director has done it.
yes,
SLC has considered your matter.
yes, Your Lordship.
Maybe I'm not going into this whether the SLC has taken a right decision or a wrong decision. That would be a subject matter of another writ petition.
Yes, yes,
But in this contempt, there's no contempt.
yes. Here in this matter, that's true, Your Lordship. But
Then why do you want to pursue this contempt? This is the contempt jurisdiction. All this court has to see is whether the order passed by the writ court has been complied or not. That's all. Though we can close this contempt you can withdraw this contempt with liberty to file an appropriate application challenging the minus of the SLC. That is, but then so far as the direction passed by this court, contempt has come to comply.
Yes, yes. No, my simple contention is like, yes, yes, it can be closed, provided your lordship that the order which they arrived at, stating therein that they have complied, that order itself, your lordship, is misinterpretation of act. That is
fine.
That is misinterpretation.
That would be a subject matter. of-
Yes, yes, read. Yes, yes.
Mr.
P. Sharma.
Learned counsel for the petitioner submits. That in terms of the order dated 2025,
Yes.
passed by the Director of Secondary Education Assam, this contempt petition can be closed. Mr. B. Kaushik, learned counsel, appears to be
Sole respondent.
sole respondent. Contempt petition is accordingly closed. You can find, you have your evidence.
Yes, yes.
What is the IA?
We are not pressing.
Okay, in view of the order passed in the contempt petition, IA staff disposed.
Grateful.
M4.
My lord, this is a contempt petition alleging willful and deliberate violation of the order dated 5/2/2024. Till date, nothing, my lord.
But I have physical letter.
No affidavit, nothing. They are sitting over the matter and lordship will stop being lenient to them, my lord. It's-
When is the next SLC sitting?
Second week of June, my lord.
Lordship will kindly peruse the directions, then lordship, everything will be clear. Page, my lord, 19 of the contempt petition, para 7. Only one paragraph I am relying.
What is taking you so long?
Yes, and the para 9, 6 months time.
Now, my lord, we have sought for attendance register.
That's fine, that's fine.
Sorry.
That order was passed in February of 2024.
Yes.
1 year has passed.
Yes, madam.
You're taking steps, why only now?
But for the purpose of verification, now we are required
That's fine. What you are doing is perfectly correct. If you have taken up your own time,
that possibly.
this process is correct. I'm not saying this process is wrong. That is there in the judgment.
Yes, ma'am.
To call for any records that the SLC may like to consider. But why are you doing it now?
Para 9, my lord, lordship will see.
29/5/2025, yesterday. Because
Well-
this contempt was listed today.
Yeah.
So, my lord, may takes it on last week of June, my lord. Because meeting will be held on third week of June, my lord.
That is not the question. Why the delay? Para 9 says 6 months, you have to do it within 6 months. Para 9 at page 20. Court directions have no.
Tanya, there's something not proper. This is not proper. Don't play with the court.
No, my lord. Maybe some reasons there are some delay, my lord. I'm not denying it, my lord. But since this is
You file an affidavit why you're taking steps
yes, my lord.
very late.
Yes.
On that basis,
Yes, yes, lordship will be. Otherwise, petitioners will not be able to enjoy their full smell. It's a regular habit now.
heard J. Patwaril and the counsel for the petitioner. Mr. N.J. Khataniar, Leonard's counsel, appearing for the
That's number 2, my lord.
respondent number 2 has furnished a communication dated
The sole respondent is there.
29/5/2025.
There is only one respondent.
Oh, for the sole respondent, huh? Wherein it is stated that the Director Secondary Education Assam has sought for attendance register of Vidya Bharati Senior Secondary School with effect from 2009-2010 to 2016-2017 from the Inspector of Schools KDC Amingo by office letter dated 28/5/2025, which is required to be produced before the next state level scrutiny committee meeting. Stop. Not for verification and examination of continuous presence of the petitioners in their school. Stop. This court is not impressed with the communication dated 29/5/2025. Inasmuch as the directions of this court in WBC number 463 of 2024 was passed on 5/2/2024. It is more than a year after the order was passed by this court. And it is only on 28/5/2025 that the respondent sole respondent is taking steps to comply with the directions passed by this court. Accordingly, the sole respondent is directed to file an affidavit explaining the delay in taking steps for compliance of the order dated 5/2/2024. Let such affidavit be filed after
2 weeks, man.
within 2 weeks. List on
Last week of June, madam. By that time, madam.
last week of June is a holiday.
No, madam, last week of June. On 26th or 25th, madam, 25th or 27th. Because meeting will be held on the third week of June, madam.
Okay. 25th.
25th, madam.
Deeply obliged.
Obliged.
Last order may be perused, your lordship. Their name has not been shown in the close list, probably for that reason.
Whose name?
Mr. S.M. Chisti, lordship, 19/5 order may be perused, your lordship.
Oh, Catania.
Notice how is it?
Notice service.
SMT Chisti was happening. In fact, here we have.
His name has not been shown in the call, madam. Maybe.
Maybe for this reason.
Okay, heard Mr. R.A. Chaudhary and the council. Registry is directed to reflect the name of Mr. SMT Chisti as the learned counsel
Both 1 and 2, your lordship.
appearing on behalf of the respondent number 1 only.
Who is
2 is also
district elementary inspector of schools, your lordship.
Notice, because this is
Notice,
a contempt petition, madam. Whether he has filed.
Notice has gone.
no column.
Notice has gone or no?
Yes, lordship. Notice was served way back in 19/11/2024 and 16/11/2024.
AT card has come back.
Yes.
Catania. Of course, this is a contempt. I can't ask you to appear, but then
I will obtain instruction, madam, whether they have received or not.
Yes, dedicated is recent. After
General counsel appearing
Maybe.
for the respondent number 1 and release the matter again after 1 week
date after
on 11 June.
lordship, can it be on 16, lordship?
16th. Okay.
July, lordship.
Item 6.
May I please, Lordship? Lordship, as per the last order of the Lodgima Court, Lordship, service has been completed, Lordship, upon respondent number 6, Lordship. So the matter may be fixed for admission, Lordship.
You file your affidavit in the
Yes,
draft
Lordship.
sheet?
Yes, Lordship. Affidavit.
Okay. Heard, Mr.
N.A. Majarbuya, Lordship.
Mother will and the counsel for the petitioner. Peruse the affidavit dated, additional affidavit dated 11 September 2024, filed by the petitioner showing service of notice on the respondent number six by Justice Service. So the affidavit is accepted and the notice on respondent number 6 shall be deemed to be complete. Secretary who appears? You appear?
Yes, madam.
You on time?
Yes, madam.
Mr. N.J. Catania, the Standing Counsel Secretary Education Department, praise for?
Forest madam.
I'll give you 3 weeks. It's 3 weeks time to file complaint. Praise a lot. This stuff in 3 weeks in the admission form.
Obliged.
I thought I'll wish you well, Lordship.
Thank you. Thank
And
you.
I was hoping the indulgence of just calling on you. That's why I was keeping track of the board.
All right.
If you'll permit me, I'll have a couple
Yes.
of.
Okay.